Good afternoon and welcome to another edition of The Law and You. Last week we started by looking at the question or attempting to answer the question whether Parliament is supreme. And Mr. Cox did an outstanding job in looking at parliamentary supremacy. We want to title today's program as Parliamentary Supremacy Part 2 because what we want to do is to be able to draw from last week's presentation and also look at some additional factors that we would want you to consider when trying to understand or to conceptualize this whole topic of parliamentary supremacy. Now, in trying to understand parliamentary supremacy, let us try to understand it from the context of the United Kingdom. Now, the term parliamentary supremacy or parliamentary sovereignty has been given many meanings. It has been given many meanings. Now, in its purest of form, we find that the doctrine of parliamentary sovereignty in the United Kingdom meant that the legislator could make or unmake any of its laws, and it was not bound by its predecessors. Now, that simply meant that, in our country, every 5 years, we have sometimes the same members going back to parliament, or a political party might decide that I want to change some of my ministerial candidates, and so some of the members who are actually elected to the National Assembly might change. Now, what the position is that any law which is made by, let's say, persons who held the position of legislators or parliamentarians at a particular time, a new set of elected members are not bound by what they have enacted, so that they can change the law, and they have the powers to change the law if they believe that there is some form of justification that warrants that change of law. Now, the role of the court is confined. And I want you to listen very carefully, because in our country there is many of matters which is now going through the court system. And sometimes you are wondering how is it that the court is going to approach some of these matters. Now, when you're dealing with matters coming out of Parliament, you have to be mindful that the role of the courts is basically confined to interpreting, applying, and administering what Parliament has enacted. So if Parliament has enacted a law, the courts can only interpret that law, the courts can only apply that law, and the courts can only administer that law which is enacted by Parliament. Now, the courts lack the power to review acts of Parliament. I'll say that again. The court lacks the power to review acts of Parliament, even if the court believes that that act of Parliament was immoral, or that it does not carry, or it was very political in its context, or there was absolutely no reason for enacting that piece of legislation. The courts cannot go to say that the piece of legislation is unacceptable because, or that it's invalid. The court's power is limited. Now, when we go on to look at the separations of power, we will try to dissect a little more in detail the functions of the court, so that you will understand the limits by which the courts will operate. Now, in trying to understand even more, Now, once the court is faced with any type of disagreement which comes before it, and in this case, they are looking at some part of or action of Parliament, the courts have a particular way in which that issue or issues must be addressed. And before we conclude on this, we will definitely look at that. Now, the courts has been apparent in the face of the law that it had been properly, that they will say that the law has been properly enacted. So if, let's say, a piece of legislation comes before the court and the court is faced with understanding or trying to solve a dispute, the courts must assume the position that the law has been properly enacted and assented to, and if it has been properly enacted and assented to, then the courts can do no more. It is only when the procedures of enactment of a piece of legislation, where the procedures have been breached in some way or form, then the courts can say, well, then a particular law was not followed. But if the law has been followed and the legislation or it's been enacted, then the courts cannot go behind that to try to understand the procedure of that enactment. Now, a sovereign parliament also has control over its internal proceedings. I'll go that again. A sovereign parliament has control over its internal proceedings. Now, there is a case law, and if you want to take in your time, you can Google it. You can Google the case of the Bahamas Methodist Church. The Bahamas Methodist Church, you may want to look at that case, and then you'll get some more insight into relation to how the courts treat with a parliament who has the power to control its own proceedings. Now, we understand from last week's presentation that parliamentary sovereignty was developed in the United Kingdom, and and as means of limiting the powers of the crown, the state, and subjecting it to a particular or popular control as ideas of democracy, as democracy and liberty started to become quite typical issues, it really started to expand the notion or the understanding of how we should treat parliamentary sovereignty. Now, in answering the question, and this is where we want to really develop this discussion today. In answering the question as to whether Parliament is sovereign, we want you to consider that Parliament is sovereign within limits. Again, Parliament is sovereign within limits. Now, one of the limits, and we will go through several limitations that we would want you to contemplate. Now, Parliament has limits. Now, Parliament in the Caribbean is a creature of the Constitution. And therefore, if it's a creature of the Constitution, it means that it is subject to the Constitution. Again, Parliament is subjected to the constraints of the Constitution or the parameters laid out in the Constitution. So the Constitution is what established, all right, the powers of Parliament. And it clearly gives the Parliament the power to make laws for peace, good order, and good governance of a country. And it also states how the powers are to be exercised subject to the provisions of the Constitution. My colleague last week said that you ought to consider the case of Collymore and the Attorney General, and we find that that is a very interesting case in which you want to consider. Now, there are certain things which came out of those learnings or those case laws. Now, Chief Justice Wooding, as he then was, stated very clearly in the case that the section which deals with the independence of the Parliament or the Constitution, that it says very clearly that the powers and the authority, and I'm paraphrasing here, the power and the authority of Parliament to make laws are subject to provisions. All right? They are subject to provisions. Now he added, and again, this is what was rightly stated by Mr. Cox last week, that if Parliament exceeds the constitutional limits which is there for them, then Parliament acts ultra vires. And if Parliament acts ultra vires, then ultimately the court's power, if litigation is instituted, the courts will have the powers to review the actions of Parliament. So right away, you must also consider that there is a limitation where Parliament acts outside of the powers given to them. There can be no Parliament in any country, more so the Caribbean, where they disobey the Constitution with any form of immunity, with impunity, and that the courts will say, I would rely on the separations of power and not review the actions of Parliament. It will not happen because all the authorities and the interpretations go down that line. Now, in trying to understand even more, we would want to look at this whole doctrine of constitutional supremacy. It's not different, it's the same thing, but whenever we're talking about constitutional supremacy, we discussed in previous occasions that it places the courts in a superior position, which gives the duty of the court through the undertaking of judicial review to look at ordinary laws to determine the consistency with the Constitution. So immediately, if you are going to consider parliamentary sovereignty, you may not want to consider parliamentary sovereignty without dissecting the doctrine of constitutional supremacy. Because constitutional supremacy will indicate clearly that the courts, they have the powers, the courts have the powers to look at the actions or look at the conduct of Parliament in terms of assessing whether Parliament has been in keeping with what the Constitution says. Now, the case of Somernet, now that is a very important case, stresses that beyond this duty, the courts is in the same as in the system of parliamentary sovereignty, which is to administer laws and not to review them. All right? So it is only where there has been a breach of the Constitution will the courts have the right or the power to review the acts of Parliament. Outside that, the case laws are very much leading down the line of saying the courts will be therefore in the same bracket or the system as parliamentary sovereignty because of the fact that it cannot review its act. Now let's look at the limits. And I want you, if you're writing, I want you to note what the limits are. Now, once Parliament observes, and this is a general position, once Parliament observes and fulfills the requirement of the Constitution, then its power is sovereign and the power is supreme. So that's a general position. I'll go that again. Once Parliament observes the Constitution, once it obeys the Constitution, once it adheres to the Constitution, once it recognizes the Constitution, then the actions of Parliament is sovereign and the actions of Parliament is supreme. Now, Parliament has various privileges to regulate its own affairs, and of course, Mr. Cox went through that on the last occasion. So while the Constitution allows the Parliament to regulate its own affairs, if there is an unconstitutional act of Parliament, then it cannot hide under the umbrella of parliamentary supremacy. So there must be a consequence for the inconsistency with the actions of Parliament. There must be consequences. And those consequences will be, one, that there can be a declaration of invalidity. A declaration of invalidity, which means clearly that the court can determine, having reviewed the actions of Parliament, can say that that rule or declare that the act or actions of Parliament is or was or is now invalid by virtue of certain things which has happened. Of course, there can be a modification, there could be severance, meaning clearly that a court can not say that the entire actions of Parliament or the entire piece of legislation which is enacted is invalid or void, but only the part in which the actions fell outside of the parameters of which Parliament has. So clearly, if one is going to answer the question as to whether Parliament is sovereign or not, one has to always answer that question in consideration of constitutional supremacy. Parliament, yes, is sovereign, but above the sovereignty of Parliament is constitutional supremacy. So everything, all organs of the state must subject themselves to the Constitution. If the Constitution is breached, then the actions of any organ is reviewable. And if it's reviewable in light of the constitutional breach, it therefore means that the courts ultimately can make a determination and declare that the actions of one party, let's say the Parliament in this case, was or is invalid. In future presentations, we are going to go on to look at the separations of power. And we are going to look at the role and functions of the legislator. We are going to look at the role and functions of the executive. And importantly, we are going to spend some time in looking at the role and function of the judicial arm of the state, which is very, very crucial for our development as a people in the Cooperative Republic of Guyana. I thank you until next occasion. Audio Jungle.